Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Thank you for joining us this evening. I will be with you for the next hour. And as you are aware, the show is designed to help address any of your legal queries. These may be queries with regards to UK immigration law, family law, employment law, criminal law, any other areas of law, but within the jurisdiction of England and Wales. You can participate in this show in one of two ways, either by ringing through to the studio on the landline number you find at the bottom of your screen and speaking to me directly with your question and query. Alternatively, if you wish not to speak to me directly but still want to submit a question, you can do so through our WhatsApp group, and again you will find the number at the bottom of your screen. All I ask is that if you are sending a question through, then make sure you provide sufficient detail for me to understand what your query is, so that I may give you as a thorough an answer and guidance as possible. Likewise, if you do choose to come through to the studio, please do mute any other devices that you are watching this show on and speak to me directly through your telephone device. Unfortunately, if you do have your volume open on any other devices, it interferes with the connection and I am unable to then hear you properly. Any questions that you are asking, please do anonymise them so that we are not identifying any individuals involved. And do get them in as early as possible so that I do have sufficient time to get through them. We do take several breaks throughout the show, and if you are putting a question to me, especially if you are on the line, then it may be that I have to place you on hold whilst we do go to those preset breaks, and then continue with your answer and your question after that break. So if that does happen, please do be patient with us. We will come back to you as soon as possible. So starting off this evening with some of the questions that you have already sent through on the WhatsApp group. As always, if there are any questions left over from the previous week, I do pick up on those first. You do have our brother Ilyas Bulbulia's show on Tuesdays. He may pick up some of those questions, and if there are still any remaining, then they will come through to me. Any questions that you send through today will also be picked up, and hopefully I'll be able to address them as the show progresses. Now, the first question that I wish to address, and it relates to an update that I have spoken about recently. We touched upon it in the last show, and I spoke about it about a month or so ago as well. And that is the changes in policy in relation to the private life applications. And we have a lot of queries and a number of queries from individuals who think that they can apply for indefinite leave to remain because they have now been resident in the United Kingdom for a period of 5 years. There does seem to be some misunderstanding and some misinformation around this policy. So just to clarify that position, I will go through that policy again and just advise you about who can apply, what the eligibility criteria is, and then how to go about making those applications. So with regards to this policy, and it did come into force on the 17th of June, so if you are hearing people saying from the 17th of June, you can apply for indefinite leave to remain if you have been in the United Kingdom for 5 years, then the likelihood is that this is the policy that they are referring to. If you are an adult, please do listen, because as I say, it doesn't apply to adults, and I'll explain as we go through the explanation and the policy itself. Do excuse me, I'm just trying to bring that up as we speak. So as we go through that, it will become apparent because there are several different categories of who can apply and when they can apply. So in terms of the guidance, it's primarily aimed at children, and many of our viewers will remember that I did touch upon this, as I say, several times over the recent months. With regards to children who were born in the United Kingdom, if they have been resident in the United Kingdom and therefore established a private life because they have been here for a period of 7 years, then those children can now apply for indefinite leave to remain upon completing those 7 years. Many of you will know that under previous immigration rules and policies, that child would at that point be eligible to apply under the 10-year route to settlement, and they would then need to fulfill that criteria, i.e. another 10 years of residence with various extensions for leave before they qualified for settlement. This current policy recognises that children who have been in the United Kingdom for a period of 7 years will have established that private life, and is therefore unfair, and it doesn't promote that child's welfare to then say, well, you've been here for 7 years, another 10 years before you can apply. So that child can apply for indefinite leave to remain at the age of 7. It's an application for indefinite leave to remain, and the application fee is £2,404 per child if you're applying for more than one child. So that's the first category. With regards to the other categories, and this is probably where the confusion is arising, there are a number of other categories. So that was the children. Now there is a young adults category, and the young adults category is this, and I think this is probably where the misinformation and the confusion is arising. So a young adult is an individual who was first given a visa based on their private life. So it was an individual who was given leave to remain in the United Kingdom based on their private life, not family life, but private life. And they were, at the time that they were given this leave on private life, they were aged between 18 years and 24 years, hence the young adult reference. So that individual will have needed to arrive in the UK at the age of 18, as a child, and then they need to have lived in the UK continuously for 5 years. So as you can see, it's limited to those young adults, not individuals who have come here over the age of 18, not adults who are here as parents and are granted under their family life route. So there are limitations. So 3 things to qualify for that early settlement for after 5 years: arrived in the UK as a child, were granted private leave to remain under the private life rules, and they were at the time between 18 years and 24 years, and they have completed the 5 years continuous residence. We do have a caller on the line, so inshallah we'll come back to the rest of that policy in a moment. I will proceed to take this call. Hello, assalamu alaikum.
Walaikum assalam, sister. Sister, I got a question.
Yes, brother.
Regarding the immigration matter. So actually, I got a pathway visa, refugee.
Yes.
So on the letter from the court when they was sending me the decision.
Yes.
They told me like your appeal is allowed on human rights grounds, and your appeal is also allowed on refugee, like it's like
yes.
asylum. Your asylum has been allowed as well.
Uh-huh.
So actually, if I go back to my country where my asylum is from, does that going to make any problem for me?
Yes.
Because it's clearly say
yes,
we're not allowed to go there.
That's absolutely right. So if you have been granted refugee leave in the United Kingdom, and if your appeal was allowed on the basis of your refugee claim on the asylum grounds, then returning to your country of origin means that you will then avail yourself of protection of that country. So it means that there is no longer a risk to you. And so the Home Office can then take steps to revoke your refugee status. The same effect if you apply for a passport for your national country. So which country are you from, my brother?
Afghanistan.
From Afghanistan. So if you apply for an Afghan passport, for example, or if you do go back to Afghanistan, then the Home Office can seek to revoke your refugee status on the basis that you no longer need the protection, and that's why you are returning or seeking the national document of that country.
Okay, and also, the court has also like, what about the human rights grounds? They also allow my appeal on human rights grounds. Does that not make any sense when they try to take action on when I go back to my country?
So, my brother, the reason why you have a human rights ground, so often when we submit an appeal for a refugee, there are human rights arguments that are engaged. So, for example, there's the Article 2 right to life, for example. And so that comes part and parcel. So if you are saying that you will be killed if you go back to Afghanistan, then as well as the Refugee Convention claim, your lawyer will have made a claim which stands and falls together. What it means is it's part of the same case. So if your asylum is refused, then your human rights is refused as well, because they're part of the same thing. But you will have human rights arguments in there. So you will, as I say, you'll have the Article 2, the right to life. Usually you'll have Article 3, which is protection against inhumane and degrading treatment. So that's the reason why you will often find that in refugee claims, you will also have an appeal allowed under human rights ground.
Article 3.
Yes.
Appeal was allowed on Article 3.
It would, because as I say, it does have an overlap with the Refugee Convention. So whilst you have the breach of the Refugee Convention, it also means that you will suffer treatment which is degrading and inhumane. And so they're both allowed together. So the fact that you have been, your appeal is allowed under human rights and asylum still means you are a refugee. And if you do go back, they will revoke your status because they're part and parcel.
Okay. Thank you very much.
Absolute pleasure. Thank you so much for your question, brother. Thank you.
No worries. Bye. Thank you. Bye-bye.
Thank you. Bye-bye. So again, for our viewers who didn't follow that, so the brother was asking a question in relation to his refugee status. It was allowed an appeal, but the brother was confused about why there was a human rights element. And often lawyers will look at all of the relating laws that apply before they lodge those appeals. And that's the reason why there's the dual grant, but they are linked together. We are proceeding to a short break now. Inshallah, please return after this break, where I will continue to answer your questions. Assalamu alaikum wa rahmatullahi. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Thank you for joining me after that short break. We are now into the second segment of this programme. Please do start sending your questions through if you do want them answered this evening. We do start running out of time once we reach that third segment and then the final segment. So to ensure you are getting the answers, please do send them through. Inshallah, I do have some questions on the WhatsApp group, so I will proceed to those. So the first question is in relation to a work experience question for a law student. Our sister is studying law at A levels and is just wanting some guidance in relation to getting some work experience. And it's a really good question. There are so many different routes to qualification now, and routes that weren't available when I qualified some time ago. But there are more kind of practical routes. There are legal apprenticeships, for example, the SQE, and the work experience route is different to the route the traditional route that many of us took several years ago. And it's really, really important to understand what your legal career will involve. It's difficult to gauge exactly what's involved in a working lawyer's day without being in the midst of it. There's lots of different areas of law. Each area brings its own challenges. You'll have heard recently on the news today the criminal bar is on strike, and the decimation of legal aid, which has caused untold misery to legal practitioners, and essentially legal practitioners who have been working off goodwill. Many not being paid for the amount of work that they're undertaking, and it's got to a breaking point where they just cannot carry on. Is that what you want to do? Do you want to be, in the criminal field, for example? go in there, get a taste of what a working lawyer's day is. You have two limbs to the profession, essentially. So you have solicitors, and then you have barristers. There are in-betweens. So there are solicitor advocates, for example. But go in, get as much experience as you can do. You go into different types of law firms. You may want to try different fields of law. There might be law firms that practice in various fields, so you can get different experience within the different fields within that law firm. Try big firms and small firms. Where do you feel more comfortable? Do you want to do advocacy? Are you more suited to the bar, and the bar being self-employed? Or do you prefer an employed position as a solicitor? So these are the things that you do need to consider. So early experience is absolutely vital. You do pick up a lot of skills, and insight, as I say, that's invaluable. Also, you might want to, in terms of work experiences, go and sit in court hearings. Courtrooms, apart from family law courts and youth courts, are public places. So you can go in, you can sit in different jurisdictions and just see how those hearings are conducted. We are a friendly bunch, our lawyers, and there'll be many lawyers in there at different levels of seniority, and they will speak to you and they will talk to you about their day. That there'll be court staff, again, they're more than happy to help. So go into a courtroom, speak to a court clerk, find out what's going on that particular day, and go to the one that seems most attractive to you. Some judges, depending on their workload and other commitments, will take the time to speak to you about their role and just the general workings of courts. You, of course, have various different places. You have magistrates' courts, crown courts, county courts. You also have the tribunals, so don't forget about those. You have the immigration tribunal, you'll have employment tribunals. So a vast amount of experience that you can get without actually going for work experience in a law firm. So do explore those, get as much of that information under your belt and decide whether or not law is actually for you. It seems a lot more glamorous from the outside than the reality. So do kind of do that, and best of luck with that. Right, moving on to the next question. I'm going to apply for my wife's extension on the 5-year route. I'm employed and have also started self-employment recently. What documents do I have to provide? So with regards to the employment, you will need to provide 6 months worth of salary slips, 6 months worth of bank statements if you've been with your employer for the last 12 months. So that's for the financial requirement. You'll also need to provide evidence that you are in a genuine subsisting relationship. So things like utility bills, letters, official letters to the property, either in joint names or separate names, to show that you have been living together for that period of time. If there are any children, then birth certificates. So there's a vast array of information in there. You will also need to provide evidence that you are that the accommodation is still adequate. So either your rental agreement, a mortgage statement, and if you are living with family members, then a letter from the family member along with their details, so their rental agreement or ownership documents, and a letter confirming that they are actually occupying the property, so council tax bill or a utility bill. With regards to English language, so at the extension level, the proficiency level is increased, so level A2. Depending on your proficiency, you can either do the A2 exam. If you feel confident to just jump straight to the B1, which will be required for your indefinite leave to remain, then you may want to do that, and that then means that you've got it for both of the applications at the right level. With regard to self-employment, the difficulty that you will have with that is that often the evidence required for self-employment income is for the previous tax year. Now, in your question, you say that you have recently started, and I don't know what you mean by recent, but if it's since April, then you've missed the last tax year. You didn't have that income, which could potentially mean if you are wanting to combine the two incomes, that you don't meet the requirements, the financial requirements. And if that is the case, and that's why you're asking this question, then do seek legal advice around your circumstances and how best to get around the issues arising there. But for self-employment, it is the last financial year, so from April 21 to April 22, and those are the documents that the Home Office will be seeking. There is a list in Appendix FMSE, extremely complex to read and navigate, but you need your accounts, you need a letter from an accountant, you need the SA 302 or 300 statement. If you've got a business bank account, you will need business bank accounts. And if you have personal bank accounts, again, you will need those for that period of time that you're using your self-employment income for. So hopefully that answers your question, brother, and best of luck with the extension application. The next question is, can you explain switching from the 10-year to the 5-year route? Yes, I can. So the 10-year route, which many of our viewers will know by now, because I have touched upon this topic several times, is the route usually where the financial requirement and the English requirements are not met. And so the Home Office will then look at any exceptional circumstances and the section EX1, the exception section within the immigration rules of Appendix FM. And so an individual will then be put on the 10-year route. In order to bring yourself back onto the 5-year route, you need to meet the requirements for the 5-year route. And as I say, the difference between the 10 and the 5 years usually is the adequate maintenance, so the financial requirement, and also the English language. And so what you would then do is, during your period of leave, if you work on your English language, get the right level, ensure that you have the adequate maintenance and meet that requirement, along with the other requirements that you've already met in terms of your relationship and so forth, and then make the application under the 5-year route. Now, when you switch, always remember that you do start the 5-year route from afresh, so they don't pick up. So if you've completed 2.5 years, you can't apply for settlement after another 2.5 years. So you will then get another, you start again the 5 years, apply halfway through after 2.5 years, and then upon completing the 5 years under the new route, you would then apply for settlement. But you do shave off the 2.5 years at the end of that 10-year route that you were on originally. So it's still beneficial to do that. Inshallah, I've explained that well enough for you to understand. If I haven't, then please just drop me another message and I'll go over that again. If you could just let me know what part I explained badly. If that's the case, then I will touch upon that only. We have another question. It's, I suffer from mental health issues. I receive benefits, so employment support allowance and personal independence payments. If I have mental health issues, can I get benefits for indefinite? And what's the procedure without reviews? The honest answer to that is I do not know. I'm not a welfare benefits advisor. It would depend on it would actually depend on what illness you have and what diagnosis you have. I'd imagine the reviews are around individuals who have a diagnosis which may change in the future. So if you have an illness now which may get better with treatment, or there may be a change in your condition, then I suspect that you would then need a review to make sure you're not on benefits. So that you're not on benefits any longer than you need to be. If, for example, you're diagnosed with an illness which is always going to be there, that is always going to be an underlying issue, a learning disability, for example, then it may be that the Department of Work and Pensions agrees that there's no need for reviews because you will never recover from this and you will always need the personal independence payments. But welfare benefits advice, Citizens Advice Bureau are the best place for that. They will go through not only what you're receiving and how that works, but also if there are any other benefits you are entitled to that you may not be accessing, or any other services. So I hope that answers your question, and I'm sorry that I wasn't able to guide you more fully, but as I say, I don't want to misguide you. So that's the information that I have there for you. Right, so we are shortly proceeding to a break, inshallah. Please do join us on the other side of this for the third segment, and I will continue to answer your questions. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Just before we went to our break, our viewers heard a question from one of our viewers in relation to them suffering mental health difficulties. If any of our viewers find that they are needing support around their mental health, there are a variety of services available for you to access. Inshallah, please do visit our website, British Muslim TV /support, for further details on how to access those services and what services are available for you. Inshallah, moving on to the next question. Quite a lengthy question, so do bear with me as I do read that through this for you. Our viewer asks, I have been married for 18 years and my husband came over from overseas. He was sponsored by me on a spouse visa. Last year, my husband returned overseas and spent some time abroad whilst completing some work in his country of origin. Upon return, I discovered that he had secretly married whilst he was overseas. My question is that at some point, I am sure he's going to try and bring his new wife to the United Kingdom. If not as a spouse, as a partner, visit visa, or business or student visa, as he knows all the tricks. We were married overseas and never registered our marriage in the United Kingdom. Can I stop him in any way possible to ever bring her here by any means? Thank you. Now, with regards to your question, so if your husband came to the United Kingdom on a spouse visa, then the Home Office will have a record of him arriving in that capacity. You don't mention what status your husband has now, but you do mention that this marriage took place, your marriage took place 18 years ago, so some significant period of time has passed. Now, in order for an individual to sponsor a new partner into the United Kingdom, they will need to establish that they were free to marry, because polygamous marriages in the United Kingdom are not permitted, even though they may be in other countries. So for the purposes of the UK law, that marriage is not a valid marriage for the purposes of the immigration rules, because he can't then bring a second wife here. Unless, as I say, that there's evidence that your marriage is broken down. With regards to other categories, so visit visas, student visas, business visas, as long as the individual meets the immigration rules, then unfortunately there is little you are able to do to stop them from entering the United Kingdom. Because the Home Office will simply be interested in them meeting the immigration rules and being satisfied that they are genuinely coming for the purpose that they are coming. So if this individual comes in for the primary purpose, for example, of being a student here, and she then studies in the United Kingdom, then she's fulfilling the conditions of her leave to remain. Whether she's in a relationship with somebody else during that period is a matter for her, unfortunately. Again, if your marriage breaks down, if you and your husband divorce, then he has the option of bringing her here as a fiancé, and there's then nothing stopping them from entering a marriage here in the United Kingdom, as long as she's lawfully here, or even having a marriage overseas and him inviting her to the United Kingdom. You are limited in terms of your options. You don't mention if your husband has returned to you and whether you are in that relationship. You also, as I say, do not mention what his immigration status is, because if he is already British or if he already has settled status, then again, unless he's acquired that by deception, which is unlikely if he's been in this marriage for 18 years, then there's very little the Home Office will do in order to revoke that status. So I am so sorry that you find yourself in those circumstances. But unfortunately, the answer to your question is that unless there's deception, there's probably very little that you're able to do at this point. Moving on, so I'm just going to go back to the policy that I was discussing, because as I say, there's a lot of questions, and rather than picking up those questions individually, it would help me to group them together and answer that question. So in the first segment of the show, I explained that there were 3 categories under the new private life policy. The first category is children who are born in the United Kingdom, who have resided in the United Kingdom for a period of 7 years. At that point, they are eligible to apply for indefinite leave to remain, as opposed to the previous regime where they applied for limited leave for up to 10 years and then settled in the United Kingdom. The second category, and the category that seems to be causing the confusion, is a category relating to young adults. These are individuals who have entered the United Kingdom as children under the age of 18, who, when they were between the ages of 18 and 24 years, were given leave to remain based on their private life in the United Kingdom, and who have then since been continuously resident in the United Kingdom for a period of 5 years. So that's the second category. That's the category where I believe the confusion is arising. The final category is adults. And a lot of these queries, and pretty much all of these queries, are coming from adults. Now, with regards to adults, the policy is as follows. So an adult can apply to settle in the United Kingdom based on their private life. So the fact that they've built up a life in the United Kingdom because they've been resident here for some time, as follows. So firstly, they must be an adult, so aged 18 years or over, that they have already been granted leave on the basis of their private life in the UK. So the Home Office has already previously accepted that they are in the United Kingdom, sorry, they have an established private life in the United Kingdom, and therefore they've been granted leave to remain on that basis. And then for adults, and this is the really important part, they have lived continuously in the United Kingdom for a period of 10 years. So not 5 years, 10 years. For those, of course, who are in between the ages of 18 and 64, they must also pass the Life in the UK test, and they need to meet the English language requirements, which, as we all know by now, are B1 level or a degree taught in the English language, unless the individual is from an English majority English-speaking country, and those are listed. So it's not always the countries that you might think are on there. So that is a requirement, and I hope that really does clarify the situation, because there seems to be an immense amount of confusion around this, and a lot of people asking about their eligibility to apply for indefinite leave to remain now that they have been resident in the UK lawfully for 5 years. So just to reiterate, for adults, if you are an adult over the age of 18 and you didn't arrive in the UK as a child, you weren't granted leave to remain on the basis of your private life between the ages of 18 years and 24 years, then you will need to wait 10 years before you can apply for settlement, not the 5 years. So that hopefully will help those people who were seeking that clarity, who were wanting to know what their options are, and how to proceed with that. Our viewer then asks a question in relation to visit visas. The question is, I am seeking to invite my family member to the United Kingdom and they have previously been refused. What documents do I need to make the application? So with regards to visit visas, there is no right of appeal. Well, generally there's no right of appeal against a refusal unless the application engages human rights elements. If an application is refused and it's a visit visa application and there are no human rights elements, then the only option to challenge that decision is by way of judicial review. And I've talked about judicial review on many occasions in previous shows, and I won't do it again this evening. The alternative and the option that most people go for is to reapply and address the issues that have arisen with the first decision. More often than not, the vast majority of refusals that we see are often based on the entry clearance officer's conclusion that this is not a genuine visit. And they will use a number of criteria to determine whether or not they believe a visit is genuine. So they will look at the reason why an individual is coming to the UK. Is there a particular reason, or does this visit appear to be just quite random? Which begs the question as to why now. If you haven't come in the last 20 years, for example, why are you making this application at this point? The second thing that the entry clearance officer often looks at is the means of the individual. So what is their financial position in their country of origin? You know, do they have quite a wealthy lifestyle? Are they affluent? Do they have a comfortable lifestyle? Or are they dependent on the family members in the United Kingdom? Because if they are dependent on the individuals on the United Kingdom, then and they don't have their own assets or means, then in the entry clearance officer's mind, that increases the chance that they will want to then stay with the person supporting them and sponsoring them. What are the ties that the individual coming to the United Kingdom has to their country of origin? So are they leaving behind family? Are they taking annual leave from their job, for example? Do they have a business that they're leaving in the capable hands of somebody else but need to get back to? Do they have children or other family members that depend on them that they are leaving behind? These are the kind of things that the entry clearance officer will look at. And the less of those factors that you have, the more the chances are that the application will then be refused unless it's really well prepared. So again, you can look at those reasons, see where the gaps were, and then resubmit a fresh application on the basis of that application. Don't forget, however, it's a fresh application and you need to meet all the requirements. Again, we're just going to proceed to another short break. This is the final break of the show. Join me after break and I will continue with this question and others as well. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum and welcome back to the final segment of the free legal advice show on British Muslim TV. I am your host, Riffat Hussain. Just before we went into the break, I was finishing off my answer to a question in relation to visit visas and the most prevalent reason for those being rejected. And that was often the entry clearance officer's view that the visit visa is not a genuine visa or for the purposes of a genuine visit. And for those reasons, they're not satisfied that the individual coming to the United Kingdom will leave when required to do so. You have to be imaginative with these applications. There's no two ways about it. Most countries don't operate similar systems to what we do. There aren't bank accounts, for example. There are many other limitations in terms of evidence. And so, thinking outside of the box is often what is required to make sure that the strongest case is put to the Home Office. unfortunately, and for those that watched the show last week, I mentioned the difficulties for most solicitors being that we pick up the cases once they've gone wrong. A lot of people now are trying the DIY version of legal applications, and then once it goes wrong, unfortunately, they are seeking legal help to put those right. And it is not as easy to do that. Once you have that negative immigration history, the negative immigration application decisions, the entry clearance officer and decision makers for future applications will always revert back to that. They will look at the reasons why that was refused. They may even refuse your subsequent application by reiterating the reason they gave in the previous application. And we see that again quite often. Early legal advice is invaluable. Getting it right the first time is no substitute. There's no substitute for that. So do consider that, because you do save yourself a lot of time and heartache going forward, particularly if you are wanting a visit visa for a particular event. You may find that you've missed that event by the time you've resubmitted an application, sorted out the mess that's been created by the refusal, and so the reason for the visit falls away anyway. So those are the kind of an overview of visit visas and how to be successful with those. Moving on, we do have another question, and again, do bear with me whilst I read this. So in terms of, forgive me, I'm just trying to bring this question up. So this was a question, and I think I may have already picked this one up, actually. It was a question in relation to, unless there's a similar question that I have answered earlier. So it's a question in relation to a marriage that has broken down. The spouse is wanting to know whether they can prevent the husband from bringing over a new wife. But I do believe that I may have touched upon that. So if you have missed that answer, my sister, do rewatch the show. It is available for you to rewatch online and on our various platforms. And your answer is in there for you. And apologies if you missed that whilst I was answering that live. So I have one final question, and this probably will take us to the end of the show, and that's in relation to, again, an immigration spouse visa, but unfortunately this time where we have a bereaved spouse. That is, an individual has come to the United Kingdom as a spouse, and the husband or wife that they have joined here, the British citizen, has sadly passed away, whilst the spouse is still on their spouse visa. And the question is, what are their options? Will they now need to leave the country because the spouse is no longer here? Firstly, condolences for your loss, and may Allah make your spouse's journey in the hereafter an easier one, and grant them Jannah. With regards to the immigration question, that there are options. So under the immigration rules, there is a route for bereaved spouses. And an individual can apply for indefinite leave to remain for settlement on the basis that they are a bereaved spouse in the United Kingdom. Fairly straightforward in terms of evidence. The Home Office will want to see the obvious evidence that the individual came to the United Kingdom as a spouse. What they will still be interested in seeing is that this was a subsisting relationship. So both husband and wife were living together as husband and wife, and that they had an intention to continue to live as husband and wife, save for the fact that the partner has now sadly died. So with regards to that evidence you may have, and again, it depends on how long the spouse has been in the United Kingdom, but things that they would be looking for is evidence of any joint financial liabilities. Do you have joint bank accounts? Do you have joint utility bills, for example? If you have children, again, that's evidence of to a certain degree, that's evidence of a subsisting relationship. So those are the kind of things that the Home Office will be looking for. The more evidence that you can get from official sources, the easier for the Home Office to determine your application. But again, like with any application, if there is a shortage of that available evidence from official sources, then again, you will need to think imaginatively as to how else you can convince the Home Office and evidence to the Home Office that this was a genuine and subsisting relationship. Without saying, you'll need to provide evidence of your spouse's nationality, so a copy of their passport, and also, as I say, a copy of their death certificate to show that they have passed. Thankfully, for these types of applications, there's no financial requirement to meet, and there is an exemption of the English language requirement, so you're not required to take the English language test if you haven't already got the right level in advance. So that there are certain criteria which are waived in recognition of the fact that this is an extremely difficult time for you and your family, and the Home Office doesn't compound that by requiring additional evidence. The application is made online, and there is a fee to pay for that, as there is with all indefinite leave to remain applications, and that currently stands at £2,404. So the supporting evidence will be uploaded online. The Home Office will require you to take biometric, enrol your biometrics, and an appointment can be made to do that online as well. So I hope that does answer your question and provides you with some relief in this difficult time. Certainly to understand that there is an avenue, certainly with regards to your immigration status, and a fairly straightforward avenue for you to regularise your status and at least not worry about that aspect of your presence in the United Kingdom. If you are struggling in terms of advice, then do try and get legal advice if you're unsure of what documents or whether or not, particularly around the evidence in the subsisting relationship. And as I said earlier, an extremely difficult time for you. There are services around bereavement and mental health available. The link was on our screen earlier, and I'm sure we can put that back up for you. But if you do visit our website at BritishMuslimTV/support, you will find details of organisations that you can access to seek that help and guidance as you may need. If there is anything else that I haven't touched upon and that you're unsure of, please do send through a follow-up question to me, and inshallah I will endeavour to get that answered for you. So that was the final question I was going to pick up for this evening. Just to mention, I didn't want to start another question and then not get through it fully or adequately before the end of the show. But do please keep your questions coming through, because if there are any, they can still be picked up for the show tomorrow by Mr. Ilyas Bulbulia. He will be here from 8 o'clock. So tune in for that. And if there's anything left over, then inshallah I will pick that up in my next show. Just to make you aware that there is no live show for me next week on Monday. We do have the Qurbani appeals on, so there will be no free legal advice show on Monday the 4th of July. So inshallah I will be returning the week after that on Monday to pick up any questions for you. With regards, on a final note, just on the back of the question that I have just answered, people often find that immigration status is one of the most difficult areas to seek advice on. There is always the fear around, if I seek legal help and the Home Office finds out, then I may be removed from this country. Any advice that your solicitor or legal representative provides you is confidential. It's also no obligation. Just because a lawyer is providing you with legal advice does not mean that you have to follow that advice. Our role is not to tell you what to do. As grown adults, as individuals with your own intellect, you make the decisions that best suit you and your circumstances. So as a legal practitioner, you will be given your legal options. You will be advised about what options are available, what the pros and cons of each of those application is. You can choose to follow any one of those if there is more than one, or you may decide to do absolutely nothing, and that's absolutely fine. Your legal representative will keep the information you share with them confidential. That doesn't go anywhere beyond you and your legal representative. What the legal representative and your solicitor is under an obligation, however, is they have a secondary duty, and they have another duty, sorry, not a secondary duty, but they also have another duty, which is not to mislead. And so what you can't expect your solicitor to do is lie on your behalf. You can't, for example, tell your solicitor that you're a national of Afghanistan, for example, but you're going to pretend in your Home Office applications to be a national of Pakistan, or vice versa. They can't do that. That would be a breach of their professional conduct requirements. But anything you want to discuss, they will keep confidential, send you away with the advice, and then you may want to act on that if you don't want to. So do always seek that help. That brings us to the end of this show. Inshallah, join me the next time. Assalamu alaikum wa rahmatullahi wa barakatuh. I hope you all keep well.